breaking news this noon. A verdict reached in the Daniel Penny subway chokehold trial.
The Marine veteran accused in the death of Jordan Neely has been found not guilty of criminally negligent homicide. Alice Gaynor is live from outside Manhattan Criminal Court, has been covering this case from the very beginning. Alice, what's the latest you're hearing?
Well, in the courtroom when that verdict was read, there was an extremely loud reaction. I can't remember another trial I've covered where there was such a reaction. Typically, the judge reminds people to keep things to themselves and stay quiet, but there was no such reminder. And when the foreperson was asked what the verdict was, she paused a moment and said, "Not guilty." Thunderous, loud applause. You had members of Jordan Neely's family very upset, also yelling out. Jordan Neely's father was asked to leave the courtroom. There was some swearing going on. One activist who has been outside demonstrating every morning was inside and yelled something at Penny like, "It's a small world, buddy." We saw Daniel Penny slightly turn his head where I saw a slight smile. Normally he stares straight forward and we can't see much of a reaction from him at all. His two attorneys, his two defense attorneys, hugged each other, smiling. They left the courtroom and we're told they left the courthouse pretty quickly. His attorneys and Daniel Penny not stopping to speak with cameras. We know a short time ago, Jordan Neely's family did stop and speak. They are very upset with this verdict. It came rather quickly this morning. You may remember on Friday, prosecutors moved to dismiss the top charge after the jury had been deadlocked on that first count, which was manslaughter in the second degree. So the judge granted it. That count was tossed out on Friday, and today they were to begin their deliberations anew this morning on the lesser charge of criminally negligent homicide. That, if convicted, was carrying a sentence of up to 4 years. But again, the jury in the case, in the trial of Daniel Penny, voted to acquit him. Cindy, Jessica?
Protests have been this common thread running throughout the course of the trial. Your notes have been meticulous. Today, the protest again evoked motions from the defense and the prosecutors. There was this ongoing argument about how much of an impact those protests might have on the jury. Can you talk to us a little bit about that?
Right, Jessica. You know, last week, defense attorneys brought this up as well. They were concerned that the jury in their room could potentially hear some of what the demonstrators were saying out here. They have megaphones, these bullhorns, and the defense today said that they heard these demonstrators chanting things like, quote, "murderer," quote, "subway strangler," and the judge agreed. He heard it as well. But he's also been instructing the jury this entire trial to ignore things they may hear. Definitely don't read, obviously, any press reports. So he offered today to, again, remind them of this or potentially take the steps to try and find a quieter room for the jury to go to. The defense declined this. They didn't want to draw any more attention to it. At one point, I was by a window and I heard some pro-Penny demonstrators cheering free Penny. So we heard from a lot of people on both sides outside today. And the problem is the courtroom is so hot. This is an old building, so they have the windows cracked. If they don't crack those windows, there just won't be any air in there. So that's also why we can hear these demonstrators day after day. But as the judge noted, it's usually just in the morning as Daniel Penny arrives, and then they typically quiet down for the rest of the day. So it hasn't been too much of a problem, the judge noted.
Alice, you have been covering this case from the very beginning along with a team of our reporters. What was your reaction? Because I heard you say earlier that you expected it to go longer, especially since they were deadlocked on the first charge.
So they began their deliberations last Tuesday afternoon, and they came in on Wednesday when normally they don't sit on Wednesdays. They were here Thursday. Friday, they sent those two notes saying they were deadlocked, hopelessly deadlocked, that they just could not come to a unanimous decision. It appeared to be very frustrating. So we thought that once they started the deliberations on the lesser charge today, because we don't know how their deliberations, what order they were doing things in last week, but they were instructed to deliberate first on count one. That would have dictated if they moved on to count two. But again, that count one of manslaughter in the second degree was dismissed. So today was supposed to start fresh minds, open minds, completely new. But they came in with a note just after 11 a.m. and they only started deliberating probably sometime around 10 a.m. this morning.
And we don't know at this point whether any jury members are going to talk to the press.
We don't, Cindy. You know, they're an anonymous jury for their protection. We don't know their names. The parties know their names because during jury selection, that's how they were able to pull up some people's social media and question them about their different views. We know very limited information about a lot of them. We know that it's 7 women, 5 men. Obviously, I can see them every day, and you have to give them a lot of credit. As I've noted in previous reporting, they've had poker faces this entire trial. A lot of those autopsy photos that were displayed were really hard to look at, and to their credit, I never saw anyone look away. I never saw anyone flinch. It's believed they might have gone out the back of the courthouse. We do have a photographer there, so if they want to talk, that is completely up to them. So we're just going to have to wait and see.
All right, Alice Gaynor live in Lower Manhattan. Alice, thank you.
Joining us now to talk more about the verdict is James Sample, Hofstra University law professor. James, good to see you as always. Were you surprised with how quickly the jury came to a decision this morning after being twice deadlocked on that top count of manslaughter on Friday?
Well, Jessica and Cindy, it's good to be with you as always. I was surprised at the pace of today's deliberations, especially relative to last week, and certainly relative to what appeared to have been a hung jury on the primary charge, the first charge, if in fact the prosecutors had decided to press ahead with that rather than to dismiss it. So it seems as though the jury would have, I mean, if the district attorney had tried to go for a hung jury, had insisted on that top charge, they probably would have had a hung jury and then at least the possibility of retrying this case. So to then proceed to today and to reach a verdict that quickly on the lesser charge is certainly a huge, huge victory for Mr. Penny. It's a huge defeat, a staggering loss for the district attorney's office, and many people questioned whether to even bring this case. But I guess my overall reaction today is very similar to what Alice was just reporting, actually, which is to say this case was a judgment call all along. It was a question of how much force was Mr. Penny allowed to use on Mr. Neely. And I'm glad, and it was clear ex ante from the beginning that no matter what the verdict was, a lot of people were going to be angry. I'm glad that the jury made the judgment call, because this case was ultimately a matter of a judgment call, a line drawing exercise. How much force was appropriate, how much force was excessive. And I'm glad, whatever the verdict, whatever the frustrations, one of the things that we can rely on in this system of justice that we have, however imperfect, is that if the process is fair and a jury of one's peers is about as fair, though imperfect, as systems get, then we can at least learn to accept the results and move on, whatever our perspective.
So let's talk about what happens next. This isn't over. Jordan Neely's father is bringing a civil case. Let's talk about next steps.
Well, certainly, Cindy, because the criminal case, there's no more trial. You don't get to appeal an acquittal. So the criminal case is over. But you're right that the pivot now will be to the civil case. Jordan Neely's father just last week, in fact, while the jury was deliberating, filed that civil lawsuit. And certainly that will take a lot of time to play out. There will be incentives to consider settlement offers, to make that go away. And a lot of people don't want to sit through another trial, but very different standards in the civil context as opposed to the criminal context, where as opposed to beyond a reasonable doubt, for example, a civil lawsuit only needs to be proven by a preponderance of the evidence that Mr. Neely's death was caused by Mr. Penny.
Going back to Friday, when the jury came back twice saying we just cannot reach a unanimous verdict on this manslaughter charge, prosecutors then moved to drop that top charge. The defense called for a mistrial, right? They're saying this is tampering with the jury's mindset. Was that ultimately up to the judge whether to grant that motion? And why do you think he was willing to say, let's drop the top charge, see if they can come to a unanimous verdict on this second charge?
It's a great question, Jessica, and I think to a certain degree, any answer that we would offer is speculative, to be candid. But I think that there was strategic posturing on both sides and a difficult strategic decision for the judge. I mean, the prosecutors were willing to drop the top charge because they essentially had a plan B, a backup option. The defense, rightly, was arguing that, well, if you the jury instructions in this case, when it initially went to the jury, said that if you can't reach a verdict, that you can only consider the negligent homicide if you reached a verdict first on the manslaughter charge, and in that case, the verdict would have been an acquittal on manslaughter, because if you had convicted on manslaughter, you don't get to the charge. And so to be deadlocked on that first charge, the prosecutors were saying, well, we've got this backup option. The defense is essentially saying, no, you're trying to give the jury a way out to still hold Mr. Penny culpable when you, in fact, overcharged the case. The judge was in a very tough spot because you didn't have a conviction and you didn't have an acquittal. And so then the question became what to do with the opportunity to consider the second charge or not. If today's decision had been a conviction on that second charge, Mr. Penny would have had a very strong case on appeal that the judge's instruction was improper. But now that goes away.
And Professor, going back to the civil case from Jordan Neely's father, so basically you're saying that the thing that needs to be proven is that he caused the death, is that Daniel Penny caused Jordan Neely's death. Is that correct?
And that he did so negligently, not just that he caused the death, but that his death was that Mr. Penny's negligence at a minimum caused his death. Now, you can establish that but for Mr. Penny's chokehold, Mr. Neely probably would not have died on that subway train, but that's not enough. It needs to be, and if I said it was just proving that it was, then that's a misstatement on my part. To be clear, to prevail in the civil case, Mr. Neely's family will need to prove that Mr. Penny's negligence caused Mr. Neely's death.
Got it. James Sample, thank you so much for your expert insight, as always. Good to have you.